Hi, I'm Kathy Bassinet. I'm one of the estates attorneys here at Gross McGinley, and today we're going to discuss the sale of real estate that's part of an estate. Usually when someone passes away and leaves a home or other real estate part of their estate, the property is simply sold and the proceeds are distributed in accordance with the person's will or to their surviving heirs. However, sometimes unique circumstances or situations call for additional steps and may require things like additional court approval or other procedures before the property is sold. For example, if the person who's appointed the executor or administrator of the estate wishes to purchase the property individually, he must first obtain prior court approval in order to purchase the home or other real estate. This is in order for the courts to oversee the conflict of interest between the executor's interest in obtaining the lowest possible value for the property and his fiduciary duty in obtaining the highest fair market value for the property in order to distribute to the potential beneficiaries of the estate. Another example where prior approval would be needed for the sale or the distribution of proceeds from a sale of a home or other real estate is if the property is given to a charity. Any real estate or other bequests that are given to a charitable organization must first be approved by the state attorney general. Attorney generals oversee the functioning of charitable organizations within the state, so they must first approve and ensure that the property is being marketed for its fair market value and the proceeds are properly going to reach the proper charitable beneficiary. The other most important aspect of selling a home that's part of an estate is the proper preparation and filing and payment of the inheritance tax. In order to properly pay and file the inheritance tax, the property must first be valued for the return. But Pennsylvania currently has 3 assessment values for real estate. The first one is the sale of the property. The second one is the property's appraised value at the time of the individual's death. And the third is the assessed value by the county assessment office. When the property's sale value is used for the assessment on the return, deductions can be taken for closing costs and other expenses associated with the property as long as the property is sold within 15 months of the date of death. Accordingly, if a loved one has passed away and has left a home or other real estate within his estate, and the family is on the same page with regard to getting that property sold, it is within the best interest of the family and the personal representative to get the property sold as soon as possible to be able to maximize any potential savings on the inheritance tax. Another scenario that can potentially complicate the sale or transfer of real estate that's owned by an estate is if the property was jointly owned with another individual. The deed to the property should be examined to determine whether the individual had an undivided interest in the entire property or if they owned a percentage share in the property to determine how much of that property should be valued for inheritance tax purposes. Similarly, if there is a mortgage on the property, the mortgage documents must be reviewed in order to determine whether the entire mortgage balance may be deducted from the inheritance tax return, or if only a proportionate share of that mortgage may be deducted from the return. If your loved one has come across an inheritance that includes a home or other real estate, contact Gross McGinley so we can assist you to administer the estate and determine the next steps necessary to sell the property or distribute the proceeds.